Assalamualaikum warahmatullahi wabarakatuh, and good day to everyone, especially to my students. I'm preparing this video actually because a few students requested me to explain in detail on the topics of variation of class rights. I believe what I've actually explained in the video earlier video is sufficient. However, there are some students who are not really sure or who don't understand, or sentences are a bit tricky for them. I try as much as possible for this video to explain it in a slightly better explanation. Okay, now we are going into variation of class rights. What do we understand by this part? Now, we must remember that there are different classes or types of shares in the company. The basic one being the ordinary shares, or what we call equity shares. And some companies, they have preference shares, to which when they issue these preference shares, normally they have a purpose of issuing. First and foremost is to perhaps to obtain share capital for certain projects, where they find it that they want to issue more shares and gets capital, which at the same time will dilute the holdings of those ordinary shareholders. So they come up with the preference shares. When we talk about preference shares, I believe some of you have actually understand that these preference shares normally they have certain criteria, such as a fixed dividends, fixed in the fixed rate of dividends, yeah, and then dividends are accumulative. In fact, with these two, it has attracted a lot of investors to actually invest in certain companies, particularly when those companies requires capital to enhance project or venture into new project. Yeah, and then there are some even introduce also redeemable preference shares, because they don't want to make the company tied up by paying fixed interest rate yearly. Because when you don't pay those not interest rate, fixed rate of dividend yearly, when you are not able to pay the dividends, most of the preference shares also have these provisions where the dividend rates can be accumulative. So it eventually it will be burden the company. But why do we have these preference shares? To attract them, but at the same time there are certain circumstances when the company would like to actually to vary those shares. When they vary those shares, so basically they are actually trying to vary the rights. Now, when you have shares, you are also having certain kind of rights. Yeah, what are those rights? Those are like entitlement to dividend, priority in terms of payment of dividend, voting rights, priority of repayment of capital, even right to surplus asset upon winding up. These are some of the rights attached to preference shares. But in general, the rights that are attached to shares are something like the voting rights, rights to attend meeting, rights to vote, and so on and so forth. Now, I would not actually discuss on those rights, but you need to understand that different classes, okay, means there are different types of shares, and these classes have also different rights. Yeah. Now, Section 88 talks about the rights that attach to the shares. Now, when you talk about the rights attached to the shares, meaning the rights of the holder of the rights of the holder as a member of the company. What are their rights? Okay, So assuming their rights is entitlement to 5% dividend rate, those are the rights given to them. They can vote, but most of the time, preference shares, or they have this limitation in the sense that their rights are restricted within their own class. Unlike ordinary shares, the ordinary shareholders would actually and can also vote in the normal general meeting. Now, the other part is that when you talk about shares of the same class, the rights attached to the shares are also identical. Now, rights in the ordinary shares are most probably not the same rights in the preference shareholders. Yeah. So, most of the company, they have these ordinary shareholders. Only few companies, they have preference shareholders. So you need to look at what are the shares, what are the rights given pursuant to those shares held by those members. And then in fact, section 90 subsection 1 says that if the company has different classes of shares, they must state in their constitution those classes of shares. Yeah. And these particular classes, when it's stated there, normally it comes with certain restrictions, certain condition. Yeah. So now those are the rights, but what is variation of class right? Okay, so variation of class rights is the changing of the rights attached to the shares. Yeah, what are the rights? What are the rights? Let's say initially when the company issued preference shareholders to a group of shareholders of A. Yeah, and they have these rights of entitlement to 5% in rate of dividend. Okay, and they wanted to change the rate, so that is changing the rights. Assuming they also wanted to change the accumulation of dividend. Let's say in the beginning they are entitled to accumulative of dividend, but if the company decided not to accumulate the dividend, that is also a variation. So basically, whatever rights that has been attached is varied is called variation. Yeah, in fact, abrogations of rights also is a variation. Now, why do companies would like to vary the rights? Okay, why can they actually vary the rights? Now, Companies Act 2016 allows the class right to be varied. Okay, now okay, when you vary the rights, there are certain procedures to be followed. Yeah. Now, before I go on to that one, I would like to explain this case first, because one of the students in my class has actually contacted me and request me to explain it to her. However, I find it is best that actually I explain to the whole of the class so that everybody will benefit with the explanation. Yeah. Okay. Now, at common law, okay, before we move on to Companies Act 2016, at common law, a variation of class right occurs only when strict legal rights attached to that class of shares are varied, and not when the economic value attached to it is affected. Now, the best case to look at is this Greenhawk and Other Cinemas Limited and another, reported in 1946. Yeah. If you read this case, I'm sure everybody has read. Let us just go through together. Now, company issued 21,000 preference shares of 10 shilling each, and 31,000 ordinary shares of 10 shillings each. So we can see that there are two types of shares. One is preference shares, the other one is ordinary shares. Now, the company's article, which is at that particular time, it was article for our Malaysian purpose, it is constitution. So, company's article provided the holders of each class of share with one vote per share. So, regardless of whether it's preference shares or whether it's ordinary shares, yeah. So, each class of shares have one vote per share. Now, the company article also provided that the company had the power to subdivide its existing share. So, whatever 10 shilling each for each share can be subdivided. Now, the company fell into financial difficulties and entered into agreement with Mr. Greenhalgh. I don't know who is this Mr. Greenhalgh, but I believe he's a very rich man, and he somehow or other, I believe he is also an investor. He lent the company £11,000. Bear in mind, this was in 1946, so £11,000 is quite a lot. And that particular loan is secured by a debenture. You know that debenture is proof of debts. Um, okay, and then he was also issued 10 shillings of ordinary shares. Now, subdivided into 2 shilling each. Now, initially, both preference shares, theirs is 10 shilling each. But for Mr. Greenhalgh, what happened was, okay, he was given this particular ordinary shares, to which that particular ordinary shares of his has been subdivided into 2 shilling each. Now, each 2 shilling shares to have the same voting rights as the issue ordinary of 10 shilling shares. Now, the dispute arose, right? The dispute arose. Company resolved at the general meeting to subdivide all existing 2 shilling shares into 10 shilling shares into 2 shilling shares, ranking equally with the subdivided shares held by Mr. Greenhalgh. Now, when he came in, okay, so the original 10 shilling has been given to 2 shilling each to him. So what happened when it was subdivided? He got something like 5 votes, correct, right? And because of the dispute, the company resolved to subdivide all the other shares. Now, the effect of this corporate action was to diminish the proportion of votes held by Mr. Greenhalgh, because when he was given the shares, right, with 2 shilling each, he has more votes than others. So this would eventually make him a big shareholders, or probably one of the majority shareholders. Okay, and then because of that, they decided to have it the same for everyone. And then in fact, they intended to ensure the blocking of passing special resolution, because Mr. Greenhalgh owned quite a lot of the shares. So Mr. Greenhalgh sought declaration that subdivision was void, okay, inter alia, because his class right had been varied without his consent. Now, let me just try to draw something here. Okay, so initially, there's in this company, they have this what is it now? Okay, they have this preference shares of 21,000. Okay, and then which is 10 shillings, and then they have this 31,000 of ordinary shares, to which is 10 shilling each. Okay, now except that when it was given with Mr. Greenhalgh, his is instead of 10, his is 2 shilling each. Then eventually everything here has been, right, it has been turned into 2 shilling. Is it the same with them? Yes. Okay, so he claimed that his class right has been varied. When he joined in the company, okay, he has 2 shilling each. When there was corporate exercise, he has been from 10 to 2. Okay, this one does not affect Mr. Greenhalgh, correct? Mr. Greenhalgh still has his 2 shilling each. Was there variation? No. That's why the Court of Appeal held no variation, because when they did this particular exercise, Mr. Greenhalgh shares initially from 2 shillings still at 2 shilling. Except for these people, their rights has been varied from 10 to 2, from 10 to 2 shilling. So court of appeal held, okay, no variation of the rights of Greenhawk had occurred. Master of Rules Lord Green stated the only right of voting which is attached in terms to the shares of that class, meaning the original 2 shillings per share, is the right to have your 1 vote per share pari passu with the other ordinary shares of the company for the time being issued. That right to have 1 vote per share is left undisturbed. So when they had this corporate exercise, right? Okay, when they have this corporate exercise, this one still remain. Okay, he still remain, but this one from 10 has turned to 2. Yeah. Okay, so the court says that before resolution, Greenhawk had 1 vote per share. After resolution, he also have 1 vote per share. The fact that the holder of the 10 shilling shares had increased their voting powers 5-fold did not amount to be a variation. Okay, that's what it means. Yeah. Okay. Although, if you read further in that particular one author from this book, Prof. Aiman says, although the court acknowledged that his rights to vote had been affected, in the business sense, we can see the business sense has been affected, since the voting power had been diluted, right? They have more. So if they have like, if he has like 11,000 unit, he only has like 11,000 unit. But if they have 31,000 unit, if it has been divided, probably it has increased. So basically voting power has been diluted. So legally his right to exercise 1 vote per share had not been taken away. Still, he can still vote for 1 vote per share. That is what it meant by this particular case. Now we move back to our Companies Act. Now, Companies Act also allows the class of rights to be varied. Now, what we see just now, Mr. Greenhawk was the common law position. Now, we are looking into the Companies Act 2016. Now, Companies Act 2016 allows the class rights to be varied. Now, when are the rights to be varied? Now, if you read in detail, Section 91, Subsection 1, they have this subsection, paragraph A and paragraph B. I would like you to actually read through those sections. Okay, you can always download from the SSM website. Now, when are those rights are varied? When the rights in the class are varied. This is governed by Section 91. Okay, and it should be the same class of shares. Yeah. Then, when the company's constitution also amend the variation rights, and when they introduce a new variation clause, and when there's abrogation, and if they introduce new preference shares, those are the position when the class right has been varied. Now, I would like you to look into Section 91. Okay, Section 91 says here, Section 91, Subsection 1 of the Companies Act says that the rights attached to shares in a class of share in a company may only be varied in accordance with the Constitution. Okay. Now, you can vary the shares provided there is a provision in the Constitution, or if there is no procedures, or there is no provisions, the variation will be with the consent of shareholders. This consent is actually falls under Section 91 subsection 1B. Okay, if you look at section 90, okay, Section 91 subsection 1 provides that you can apply, you can vary the shares, but there are 2 methods of varying. First one, when the Constitution provides, when the Constitution provides for variation. Okay. This is governed by Section 91, subsection 1A. Please look into detail in the Act. And secondly, how can you vary? If there is no provision, okay, no provision in the Constitution, how you can vary? This is in accordance with Section 91, subsection 1B. Okay, you requires consent. You requires consent of, okay, consent of shareholders. Consent of shareholders. Okay, in that class. In that class, the one class which you want to vary. Okay, but for this purpose, for this section 91 subsection 1B, okay, consent, how can you get consent? So you have to look into section 92 section 91 subsection 2. Okay, section 91 subsection 2, okay, A, which says that written consent, okay, written consent not less than 75% of the total voting rights. Okay, that is how you get consent. Or okay, or this is provided by section 91 subsection 2B, special resolution. Okay, pass by the shareholders in the class. Okay, that's how you get the consent. First one by written consent, right? Second one by special resolution. So this is governed by section 91 subsection 2, paragraph A and paragraph B. Yeah. Now once varied, what happens? Once varied, okay, there is a requirement that you must submit to SSM within 14 days from the date of variation. If you don't submit to the SSM, you are breach the Companies Act, and you will be any officer who contravene, commit an offence, and be liable to fine which is not exceeding 10,000 ringgit. Okay, and in the case of continuing offence, meaning you still not submitting, you still not paying, a further fine not exceeding 500 ringgit per day, which is a lot of money. And this is governed by section 95, which you need to lodge with the registrar. Okay, this is when you have obtained the consent, when you can actually vary. Now what happen if you are the shareholders, you don't agree to the variation? What happen when you don't agree? Can you apply, or can you challenge? Can you challenge the variation? Yes, you can challenge the variation. This is governed by section 93. Section 93. Have a look at the section. Do I have here? Yes, I have here. So section 93 empowers the shareholders representing at least 10% of the affected class. So if is the one affected is preference shares, so 10% required to enable the shareholders to apply to court to have the variation disallowed. So application shall be made within 30 days from which the variation is made. And then once the court hear the application, the court can make one of the order, to which first one, if the court satisfied with the variation, and it will unfairly prejudice, okay, the shareholders represented by the applicant. So the court will disallow the variation. Otherwise, if the court is satisfied that the variation would not unfairly prejudice, the court can confirm the variation. Okay. Now, same thing. Once you confirm, if it's confirmed with the variation, company shall lodge the order made by the court to the registrar within 14 days from the making of the order. So failure which all the officers who did not follow the provision will be liable upon conviction to a fine. Now, there's another part which I would like to touch. This is section, if you look at section, I don't know whether it is here, section 95. Yeah. Okay. Section 95, okay, that talks about the submission. There's another one here. Okay, variation includes abrogation. So if you abrogate the rights also, that is a variation, which I believe I have mentioned before. Now, the other one which is also important, which is section 91, subsection 5, which says that it is deemed an issuance by a company of preference shares ranking equally with existing preference shares to be variation unless the issue of the preference shares was authorized by the terms or by the constitution. Now, let me just show how it works. Yeah. Okay. Okay, this is for section 91 subsection 5. Okay, assuming that is the preference shares, assuming there's preference shares, we call it type A. Okay, type A. Okay, when they issued these preference shares to the shareholders, okay, let's say a group A. Okay, group A. When they issued, sometimes they already inform. When they issued to group A, they already inform, assuming there's a terms in the issuance that, okay, that the company can issue another, okay, preference shares. Okay, or when they issued the first one, there is also a term in the constitution, okay, allowing, okay, for issuance, of preference shares, okay, other than the existing preference shares. Meaning to say, when shareholders of group A, when they actually invested, okay, in the preference shares, they were already informed by the company that, look, we are going to issue some more preference shares after you, and if you agree, just sign it. We're going to issue preference share type A to you, and okay, that is a term. Or during that time, there is a constitution in that particular company saying that it allows the company to issue another preference shares other than the one existing. Now, when there is such provision, there is no variation. Okay, when they issue a new one, let's say for group B, there is no variation. However, when there is nothing here, okay, and they still issue, let's say they still issue the group B preference share, there is a variation. That is the difference. That is what it meant by section 1, section 95, sorry, section 91 subsection 5. Yeah, that's why it says here. Okay, uh, issuance by a company of preference shares ranking equally with the existing preference shares, okay, to be a variation, okay, unless the issue of the preference shares was authorized by the terms of the issue of existing preference shares, meaning, there was terms of reference, or by the constitution in force at the time the existing preference shares were issued. Yeah, so basically, if it was allowed, then there was no variation. Okay, so that's all you need to know about variation. Have a look at the question which I gave. Okay, it's not that difficult, it's very easy. Try to answer those assignment given and submit within time. Thank you very much. I hope it helps all of you.